So we are very happy to have Professor Kohl, Professor of Commercial Law at Southampton University, to speak about toxic recommender algorithm. So she will touch upon very important laws, which includes the EU Digital Service Act and the UK Online Safety Act. So Uta is a very prolific scholar in the field of law and digital technology. She has published widely on different issues of internet law, digital technology, data governance, etc. And here at CUHK Law, we are extremely lucky and happy to have her as a visiting professor in law and digital technology this year's and also the previous year. So without further ado, please join me in welcoming Uta. Uta, the floor is now yours.
Thank you, Gian, and hello, everybody. Thanks, Gian, for inviting me to present here, and thank you, everybody who's turned up for listening to me. So I'm going to present a paper I have already written, but generally I present on things I haven't written, so it puts me in a slightly more solid position on toxic recommender algorithm, and I will be looking at them from the perspective of the Digital Services Act and the Online Safety Act. Now, I came to this topic because I was asked to write on the Online Safety Act and Digital Services Act in the context of a special issue. And both of these acts are designed to make platforms more responsible actors in the online sphere. So when I first looked at the Digital Services Act, and to my shame, I hadn't properly engaged with it, I was, until then, I was surprised to see that the very first thing which you see in the Digital Services Act, the very few first sections are all about giving platforms immunity, giving intermediaries immunities. Now, these immunities are not new. They've been around for a long time. They were given in the EU to online intermediaries in the year 2000 with the Electronic Commerce Directive. They followed in this footstep of Section 230 of the Communication Decency Act in the US. And in China, you have the same immunities, or not the same, but very similar immunities by virtue of the 2006 regulation on the protection of the right of communication to the public of information networks. So in the early 2000s, in the late 1990s and early 2000s, there was a fairly strong consensus across East and West that platforms occupied this special status which entitled them or which made them deserving of these immunities. And these immunities are very broad. They cut across civil law, they cut across criminal law, and they are immunities for liability for third-party wrongdoing on the domain. I will spell it out a little bit more specifically later on. Now, of course, a lot has changed since the late 90s and the early 2000s. I mean, the internet is no longer as innocent as it was. And, you know, we have had lots of disinformation and misinformation campaigns in the context of, well, of the pandemic, but also in the election context. There's been lots of harmful content and viral challenges to children. The hate, racist, misogynist speech is booming online. And this is all very well documented. And so the question is, does it still make sense to give platforms immunities? You know, particularly too against the context that platforms were given these immunities to encourage them to moderate their domain, so to exercise moderating powers, and not just that they do take up these powers, but they, in fact, there's also evidence that they have made it worse. Now, so it's somewhat counterintuitive that legislation which is designed to responsibilize platforms starts off with immunities. It's not, this is not how we make people or actors, entities accountable. We impose liabilities. We don't give them immunities. So what's going on here? So the broad scheme, which the Digital Services Act, the Online Safety Act, and legislation in Europe, as well as in Australia and various other places, is designed to do, it's designed to set up a type of co-regulatory regime, whereby you keep the immunities, which means you keep a self-regulatory space, but what you do is you impose framework or overriding duties that inform the self-regulation by platforms. So self-regulation plus broad duties and framework requirements are meant to work together to make the world a better place, certainly to make the internet a better place. Now, the European Commission sort of retained the immunities with the words saying the immunities are by now established as a foundation of the digital economy. And I thought to myself, well, that's a little bit too easy, and that's a little bit too, I decided to look into it a little bit more, particularly against the context that, you know, you don't immunize actors if you want to make them more responsible. So what's going on? And this is really what my talk today is about. Now, let's start with the facts. And the facts are the facts around recommender algorithms. What impact have they had on the online sphere? And the hypothesis on which my paper is based and my argument is based is that recommender, or at least an initial one, that recommender algorithms have made the online sphere worse and not better, and that has been facilitated by the immunities, and the immunities continue to do so. So now there is a fairly, so the first thing is about facts. What has happened in the online world? And here we have a fairly broad body of empirical evidence that has shown that recommender algorithms do not amplify content and harmful content in particular in two ways. One, they amplify it in a quantitative way, which is, I mean, this is what a recommender algorithm does. So, you know, it brings harmful content to more people. And we might say, well, you know, there may be arguments about whether they should engage in content moderation, and clearly the arguments are very strongly in favor of that. But the second thing, which is perhaps the more astounding thing, is that recommender algorithms do not just amplify harmful content in a quantitative way, but do so in a qualitative way. As this increases user engagement, and once you increase user engagement, you increase user watch time, and thereby exposures of users to advertising. So the platforms we are talking about here are the platforms that monetize content through advertising. Yeah, so it doesn't apply to all platforms. I'm thinking here about, you know, the large social media sites, YouTube, TikTok, Facebook, Twitter, the very large, well-known platforms in the West, and I know you've got similar platforms in China as well. Now, the escalation of content, of qualitatively the escalation of content was the foundation for a case brought against Google, Facebook, and Twitter by the families of the victims of terrorist attacks in France, US, and Turkey. And these families brought a civil action against these platforms for aiding and abetting international terrorism. And the allegation was there that And the platforms didn't just distribute those Islamic propaganda like the beheading videos, but they in fact contributed to the radicalization of users in the West and in the East, and wherever the platforms were available. And I'm reading here a quote. I don't really want to talk about this case, but I just want to stress the point that platforms are considered, or have their algorithms are considered to contribute to the escalation of content that is fed to users. So a quote from an amicus curiae in the case, which actually came to the Supreme Court in 2003, US Supreme Court, this quote reads, "Google knows that their most enticing and addictive content is often intense, violent, or tortious. YouTube may be one of the most powerful radicalizing instruments of the 21st century, constantly increasing the stakes by taking a user to more extreme content than where the user started. Sites that want to monetize their troves of content have an incentive to keep users coming back, to keep them on the site as long as possible." So in other words, outrageous content is profitable, and of course what is outrageous is in the eye of the beholder, and you as a platform, you are incentivized, if you want to keep users online, to up the stakes as the user engages with the platform. A more recent empirical study to very similar effect is by UCL and Kent University. They published their findings in January 2024, and they set up, as part of the study, there's loads of evidence on this around. They published their study in 2024. They set up test accounts where they declared the interest, masculinity, and loneliness. And after only 5 days, there was a fourfold increase in the level of misogynist content that was proposed, that was recommended to the users, to the fake users of these accounts on the For You pages of the individuals' TikTok accounts. So they were presented with 4 times as many videos with content including objectification of women, sexual harassment, discrediting women. And this had increased from 13% of the recommended videos to 56%. So again, the conclusion was that these algorithms privilege more extreme material, and which then of course increases the usage, and users are gradually exposed to more and more misogynist ideologies. Now, of course, platforms interact when they fine-tune their algorithms, they interact with human nature. And again, there's lots of empirical evidence that suggests that users get greater dopamine hits, which is the sort of chemical bound up with motivation and rewards if your posts receive more likes and more shares. And you're going to get more likes and more shares if you distribute content that is more sensationalist. So for that reason, sensationalist or fake news and misinformation is routinely more shared than sort of measured articles which look at all sides and engage in a rational type of debate. Now, of course, sites set the social media interface in such a way as to maximize things that keep users engaged. So likes and shares and counting likes and counting shares are things which platforms know, which we all like. Now, So this is in terms of the recommender algorithms. This is some of the evidence which is out there, and I've just mentioned a fraction. There are empirical studies that provide counter evidence and that argue, okay, recommender algorithms are actually not as bad as you think, and they are actually distributing, like, you know, the same both harmful and non-harmful and positive content in the same way. The point here is not so much to argue about this point, but rather to say at least it is arguable, at least there's evidence that suggests that platforms are implicated in the shape and form of content consumption, in the demand and supply of content consumption, and regulated. Now, before I want to move on to how this might have been different, but for the immunities, I want to also very briefly mention the other side. So recommender algorithms is a way in which platforms arguably positively encourage harmful content. The other side to the coin is to what extent do platforms responsibly moderate online content? And here the example I want to bring is TikTok's so-called blackout challenge. It's also called the choking challenge. It went viral in the late 2010s, so in 2019 and 2020. It was a viral challenge amongst kids and teenagers. It was an extremely dangerous challenge which involved the self-asphyxiation, which was belts, purses, strings, anything that would asphyxiate you, plastic bags over your head. And the idea with the challenge was that you would become unconscious. It was very dangerous, and not surprisingly, lots of kids died. So there were at least 20 kids that died as a result of participating in these challenges. A number of actions were brought against TikTok. One of them was by a mother of a 10-year-old girl who died after participating in the challenge. She brought an action in the US against TikTok on the basis of product liability, negligence, and wrongful death. So this was a civil action. The case was thrown out in 2022 by the district court in Pennsylvania because the court said TikTok had no liability in relation to content uploaded onto its platforms because under Section 230 of the Communication Decency Act, it was immune. And in the US, the immunity even extends to platforms that have knowledge of the wrongful material being online. So this is slightly different in Europe. In Europe, the immunities of hosts require content hosts to take material down once they have specific knowledge of the wrongful material. Now, there is a slight footnote to this case in that in August 2024, so very recently, the decision by the district court was overturned by the Third Circuit Court, which held that Section 230 does not protect platforms for their own wrongdoing. Yeah, so in other words, here the judge said that the TikTok's behavior in terms of recommending these viral challenges lay outside the immunity. Of course, that doesn't actually mean that TikTok would be liable. All it means is, but this is what I'm arguing for, what we need to have, all it means is that an action for negligence or product liability or wrongful death can be brought in courts to challenge behavior of platforms. Yeah. But the immunity has meant that these actions would be thrown out in summary judgments, and you would not even come to debate whether or not they were negligent. Now, so this is the broad factual background what has happened in terms of you know, platform behavior online, the online infosphere, which has had been exposed, lots of vulnerable minorities being exposed to very toxic and harmful content. Now, second point here, what would have happened if the immunity had not been there? So this is sort of imagining an alternative reality. If we hadn't enacted these immunities in the late 90s and early 2000s, would the information sphere have looked the same as it does today? Yeah, and of course, I cannot say for certain what it would have looked like. All I can argue is what laws would have been in place to challenge platform behavior. Yeah, so it's a type of counterfactual analysis and say, look, what laws are out there with which you could have challenged platform recommender algorithm, which you could have challenged platform moderation or the lack thereof. Now, in my article, I look at a number of things. For today, I just want to mention one as an example of criminal law. Yeah, an example in the UK of criminal law is the Corporate Manslaughter and Corporate Homicide Act of 2007. So you have an act that is specifically directed at corporations and looks for gross negligence and looks for an organizational fault. Yeah, the idea is, was there is a type of system intentionality? You don't look at what any particular individual in the corporation did or thought or didn't do, but you're looking at the corporation system, at the corporation's policy. And in fact, I'm reading out, this is from the act itself. You look at what senior management intended as a body, but as part of that, you look at attitudes, policies, systems, and systems would be actually algorithms, or accepted practices within the organization that were likely to have encouraged such failures. So that were unlikely to have encouraged such gross negligence. Yeah, that would unlikely to have encouraged, you know, viral challenges of the sort of TikTok or misogynist and racist and hate speech of the sort which we find everywhere else. Yeah, and you then ask the question, should the organization be held responsible for corporate manslaughter? Now, I'm just basically throwing this out in the room. That would be, of course, to apply that to platforms would be a very, you know, fact-intensive inquiry. Yeah, you would actually have to investigate what were the policies, what was known, what was not known. But of course, you also have statements. So I've got in my article a statement for someone who worked for Facebook. And I think he was in the user engagement department. And they took initially user engagement always as a proxy for user benefit. So the more engaged users are, the more beneficial it is. And then he, by the time he gave evidence before Congress, he said, actually, very soon became clear that user engagement does not neatly translate into user benefit. Yeah, still, even though Facebook knew that, they still used user engagement as the trump card that trumped everything else. Yeah, regardless of its consequences. And this is the sort of thing which would have fed into an investigation of whether there was gross negligence leading to the death, you know, in the TikTok case of many children and teenagers. Now, corporate manslaughter is a pretty rare prosecution. It's even rarer being successful. So a much more likely avenue to hold platforms accountable would have been negligence. Yeah, negligence is really your routine intervention when you want to hold an actor, like like a platform accountable for systemic wrongs in the organization. And in fact, negligence in the duty of care is very much the basis of the Online Safety Act. Yeah. Now, but this is only now. So negligence would have been a routine intervention. Now, when I say a routine intervention, but for the immunities, of course, negligence is very circumscribed. You can only bring an action in negligence if you can show that someone suffered personal injury or that there was injury to property. There was some property damage. Yeah. So you need to show damage to life, limb, or property. And that would have cut down on lots of actions, but again, it would have picked up on the most harmful activities. Now, how would negligence have dealt with these platforms? Yeah. How would it have applied to the platform responsibility or otherwise of third party doing unwholesome things on their domain? Now, in negligence, you get a doctrine which says that, and I've cut out all cases and so on. You can find cases and everything in my article. You get a doctrine which says an owner of property has a duty of care to take reasonable steps to abate known dangers created by a third party on their property. So if you own a piece of land or if you own a house and let's say it's empty and abandoned, you still have a certain responsibility in relation to that land and to that house to prevent third parties entering it, using it, and harming other people. So you need to take reasonable steps to abate known danger. Now, what is a known danger? A known danger is a danger which a platform, oh, sorry, I haven't actually, before I come to known dangers, if you apply that doctrine to platforms, you could argue that a platform has a duty of care to take reasonable steps to abate known dangers or created by third parties on their domain vis-a-vis outsiders, yeah, or vis-a-vis users of the platforms, like children, yeah, or like women, or like other minorities. Now, okay, more specifically, what is a known danger? A known danger is a danger which a platform actually knew about it or could have known about it. So it's actual or constructive knowledge. Yeah, so you don't need to know that there's a particular viral challenge, but if you hear about or if you know that these things are being spread on your platform, you would be under a duty to take reasonable steps to abate the danger. Now, the reasonable steps must be proportionate to the level of risk, proportionate to the probability and the severity of the harm, taking into account what is technologically and economically feasible. This is part of bog standard tort law, yeah? And this is something which could have very easily applied to platforms, but for the immunities, yeah? Platforms would have been required to take reasonable steps to abate the most severe or the highest danger in relation to the most severe harm. And that would have undoubtedly protected some of the children that were exposed to these viral challenges and to lots and lots of other very unwholesome sites. Okay, now the point here is in relation to negligence is to argue, one, there wouldn't have been a problem, a massive problem of floodgates because negligence circumscribes action by virtue of the requirement to suffer personal injury or damage to property. There are some limited exceptions. Secondly, negligence is not just responsive to the past. So it's not just responsive to the injury suffered by the victim, Negligence has a very systemic and forward-looking element. So in other words, when you know negligence applies to your operation and that you owe a duty of care, you will and should put systemic guards in place, systemic measures in place that could prevent injuries from arising. The reason why I'm emphasizing this is because one of the supposed benefits of the Digital Services Act and the Online Safety Act is that they impose system duties, that they are, you know, they are focusing not on an individual, but they're focusing on the system. And this is the more important thing we should be focusing on. My argument is that, of course, traditional civil law also focuses on the system. It focuses on the system in terms of finding the fault, and it focuses on the system which ought to be put in place to prevent liability. Yeah. Now, once again, this does not actually mean that platforms would necessarily have been liable. Yeah. So if the immunity hadn't been there, doesn't mean there would be necessarily liability on the side of the platform. What I'm arguing for is if the immunity are not there, it hadn't been there, we would have been able to debate these things in courts. Yeah, so these things would have arisen in the open justice context of courts, yeah, where media would have reported on these decisions, and that therefore it would have become part of a wider democratic deliberation on how platforms should or should not behave. Now, third point. So this was the sort of counterfactual. The third point is, so what has gone wrong with the immunities? This seems to be a slight sort of cognitive dissonance in that the immunities seem to be, you know, immunizing platforms for their own wrongdoing, whilst in fact they were designed to immunize platforms for the wrongdoing of third parties. Yeah, they weren't designed as a free for all. So all the immunities, certainly I have not investigated the Chinese law on this, but what I have read is that China very much stepped into the footsteps of Europe and the US in creating these immunities. And certainly in Europe and the US, the immunities are not a free-for-all. There are conditions attached to it. And the conditions are really, and in some ways, quite simple. So you as a platform or as an intermediary, you're only immune if you can show that you are neutral or passive. The idea being is you are just this inanimate pipe and the content goes through you and you can't really do anything about it. All you're doing is you're allowing the content to travel from A to B, but you have no influence on it. Yeah. So neutrality and passivity are sort of the backbones to the immunity both in the US and the EU. By implication, if you're shown that you're not passive and that in fact that you are active and that you are not neutral, then you are liable like any content provider. Yeah, so there is the deserving intermediaries and the non-deserving content providers or users, so basically the parties who put this stuff up. Yeah. But you need to show that you are neutral, passive, intermediary, that cannot be blamed for what has happened because you have just provided these static pipelines through which the content flows. Now, how has this been interpreted by the courts? And you might already be able to guess the way courts have interpreted is very broadly, because if they had interpreted narrowly, they would have certainly caught in the net the big platforms because they're not really passive. They're not really neutral. So the interpretation in Europe, the interpretation has been slightly different because the wording of and the scope of these immunities is slightly different. In Europe, broadly speaking, the immunities have been interpreted by, as an intermediary, you are immune if you have no actual knowledge of specific wrongdoing. Yeah, that gives you your neutrality. You didn't know. Yeah. So in other words, another way of putting it is actually that the European jurisprudence does not at all engage or recognize with the possibility that the algorithms themselves, the sort of technology, can be non-neutral. Yeah, you need to show that someone actually told the platform, oh, by the way, there is a very nasty viral challenging going on your website. Yeah. In the absence of that actual knowledge, you're considered neutral. In the US, they've taken a different tack, but it has led to pretty much the same outcome. In the US, you have to show that the platform contributed to the illegality of the message. Yeah, so you need to show not just that the platform amplified the message, yeah, and amplified the message in relation, substantively in relation to the particular user, but you need to show that the platform actually did something that increased or contributed to the illegality of the actual message. Again, this is not what platforms on the whole do. There are one or two examples where they have found actually these platforms did contribute, but you know, the main platforms are not considered to contributing to the nasty message itself. Okay. So this is the interpretation, and I think that interpretation has gone very wrong. This interpretation should not have been as it is. Now, I put two arguments there. One, and this is an argument in a way very specific to the European context and all the legislation which has been sprouting up out of the grounds everywhere in Europe, in addition to the Digital Services Act. And that is that the Digital Services Act very clearly recognizes platforms as active participants in the content sphere. Yeah, platforms are not these are not these passive pipes through which content flows. Yeah, and in fact, the driver behind the Digital Services Act or the Online Safety Act is in fact to address the active mismanagement by platform of online content. Yeah, so I say there's a complete mismatch between the underlying assumption of the self-regulatory duties, which recognizes the active non-neutral nature of the platforms, and the interpretation of the immunities, which says, oh, these are just these passive static pipes through which content flows. And that's one thing. So these two things don't really go together. Yeah, platforms can be one or the others, but they cannot both at the same time in relation to the same content. Now, the other thing which I'm arguing, and this is probably the more important argument, and that is, well, what was the rationale of the immunity? Why were platforms given the immunities? And the rationale, there are arguments about it, but broadly speaking, the rationale was, starting in the US, to encourage platforms to assume editorial discretion, to moderate. Yeah, so the rationale was to not scare platforms with liabilities on the basis that if you assume control, you will then also be held liable. But the idea was, you won't be held liable, but we want you to assume control over the online sphere. Now, this is not what platforms have actually done. Yeah, so they have assumed control over the online sphere, but not in the public interest. Yeah, so in this context, I argue in this paper that platform neutrality should be interpreted wholly differently. Platform neutrality ought to be interpreted as like judicial neutrality. In other words, is the platform sufficiently neutral in relation to the content it's meant to moderate to discharge its moderation duties without a conflict of interest. Yeah. This argument very clearly shows that actually platforms are conflicted moderators. They have an interest to moderate content, but not in the public interest. And because they have because by virtue of being ad finance, by virtue of the fact that outrageous content is profitable, they do not have the neutrality and the lack of a conflict of interest to discharge their obligation as moderator in a neutral sort of way. Therefore, I'm saying any platform that is too invested, personally invested in the content it's meant to moderate, very clearly falls outside the immunity, very clearly is not the neutral platforms which it should be for the purposes both of the European immunity and the US immunity. Okay. Now, this conflict of interest has been recognized in various other contexts. It's certainly been recognized in the competition law context. Yeah, a platform, a search platform like Google is both an infrastructure provider, but at the same time competes with market players in terms of what it ranks in response to search results. Yeah, and so the idea here is, and I don't want to go into that, but I'm just saying in other pieces, certainly recently of European legislation, there is a recognition that platforms very often are in a position of, in conflicting positions where they're being given, where they have powers, but they're also exploiting this power, and the law intervenes. And I'm saying the law in the immunities context should intervene in relation to platforms that are too invested in the content they're meant to moderate. Okay, final part of the argument, and that will not take very long, is, well, okay, so I'm arguing that the immunity should be interpreted in a much more restrictive way, yeah, or in a different way, certainly, yeah, and that there are mismatch with the Digital Services Act and a mismatch with the core regulation in the Online Safety Act in the UK. Now, an argument in response maybe is, well, does it really matter? Because actually now we have all these new pieces of legislation and they create co-regulatory regimes, and now you have regulatory authorities that keep an eye on platforms, and so we don't really need these private civil actions to hold platforms accountable. Two responses to that. One, individual redress. Yeah, individual actions provide a redress to actors, to individuals who have been harmed by virtue of the platforms, and this is a fundamental rights and various sort of very basic fundamental human rights documents, an effective right, and a right to an effective remedy or effective redress. Yeah, and this is what civil law like negligence gives. Secondly, I know this is probably controversial, but I don't actually have much faith in co-regulatory regimes. Certainly in the European and in the UK context, a lot of co-regulatory regimes have been extremely disappointing, where for good and bad reasons, regulators haven't been half as active as you would want them to be. Yeah, this might be in the environmental context, this might be in the data protection context, but in other words, I say actually a co-regulatory regime would benefit from having civil actions as a type of check on the co-regulation, because regulatory failure is always a problem. There's regulatory capture, government and platform, big corporation entering actually into a pretty cushy relationship. Both are dependent on one another, and this then means that the law may be on the paper, but not actually being implemented. And on that basis, I think we need to get the civil actions and platform behavior back in the courts where they can be debated. So I'm not saying platforms are necessarily liable, but I want to see platform liability or the potential of platform liability being exposed in the courts. Thank you.
Thank you, Uta. This is super interesting. So we get a question from the audience, but I also want to use my privilege as the moderator to start the discussion. So I think it's so interesting to see the liability of the platform. And you mentioned that we probably need to ask the platform to take some measures, follow their duty of care to be exempted from the liability. I'm just wondering, to what extent do you see the platform might still try to get away from the liability through contractual design or the different kind of a procedure design? So for example, the platform might just in the beginning put in the term of use to its users that, hey, I am using this taxis algorithm, you know that, and you still want to use my service. So I don't actually have any liability to you. Or if that is possible to for platform to kind of like get away from liability through this kind of disclosure, or if by contract terms you can just ask the users to waive any right against the platform.
Okay, thank you. I think, I mean, two things which I can think of almost immediately. One, contractual terms would probably not be binding on children, for example. Yeah, because you have contractual capacity at the age of 18. Yeah, so that would already capture quite a wide range of vulnerable users that ought to be protected. Secondly, as I said, I mean, negligence only deals with the most serious harmful consequences which you might get online. And as I have just learned doing a contract seminar this week on the control of exemption clauses ordinance, you know, you cannot exclude liability for personal injury or death caused by negligence. So there are the sort of normal constraints on, you know, trying to get around contract law. And I suppose I have, the whole thing is actually, my whole argument is based on a very strong faith in civil law, in much stronger faith in civil law than in core regulation, a strong faith in civil law, a strong faith in the restrictions put on civil law, like, for example, on exclusion clauses or exemption clauses. And at the same time, what interacts with that as well is that I'm arguing this context is not so different as to require this special status of platforms. I mean, platforms, and this is actually the last point which I forgot to make, was that currently, by virtue of the immunities, platforms are beyond a lot of private law, yeah, and copyright law is an exception, so they are not beyond copyright law, but you know, they are beyond negligence law, they are beyond defamation and beyond nuisance, they are also beyond product liability and so on. Secondly, so you take them out of private law, and then do you put them into the category of public law? Are platforms suddenly subject to the restraints put on governmental actors? And the answer to that is no, they aren't. So in other words, they're not subject to private law, they're not subject to public law. And you think, wow, who are they actually subject to? What is the law they are subject to? Yeah. So I mean, that's a very long answer to a short question, but yes, so I do feel that the law as it stands, civil law, would be able to cut down some of the sort of contractual ways of trying to work around negligence in a lot of circumstances.
Yeah, in terms of private law and public law, you made a very interesting point, which is that we might need to require the platform as neutral as the judiciary. That is actually a pretty innovative argument. I agree with that, but if there's any dispute, so who should bear the burden of the proof? So because sometimes it's not that easy to find direct evidence proving that the platform had some conflict of interest. And also because they are still very different, but your argument is very similar to some of the previous argument that we view this kind of like service provider as some like public infrastructure. Like in communication law, they also have the common goods carrier obligation.
Yeah.
So that is actually something very interesting and worthy for more exploration.
Yes, and I mean, to respond to that, I mean, the Digital Services Act, possibly more so than the Online Service Safety Act, recognizes that platforms are not just normal private actors, and it imposes on them duties which you would not normally have imposed on a private actor. So for example, if they check someone, if they suspend someone's account, they need to give an explanation. Yeah, but I mean, normally a private actor, if someone comes into my house and I say, oh, can you please leave? You know, I don't need to give an explanation why I want a person not to be in my house or my land. Yeah, so there is certainly some recognition that in the legislation that platforms occupy a place of a sort of quasi public actors and therefore are at least exposed to some procedural requirement to ensure a certain legitimacy of their decision or a certain accountability of their decision making, which normally you don't have for private actors.
Right,
yeah?
right.
Now, when you also ask about burden of proof, I mean, one of the things which might be handy in terms of, let's say, if you brought an action against a platform for negligence, yeah, and you say, this action caused my child or, you know, someone to suffer personal injury because they did this, blah, blah, blah. One of the doctrines which might be helpful in negligence is res ipso facto, oh, I can't remember the exact Latin word, but it is the facts speak for themselves when then the burden tips over to the platform to show that they have done everything possible to prevent a particular state of affairs. Yeah, so I think again, you know, having much faith in traditional law, I think there are doctrines that would empower civil parties in bringing actions against platforms.
So my last question is that, the focus of the paper is about the increasingly toxic recommender algorithm. But do you see there's a potential for the argument to be also applicable to the deployment of other technologies, such as generative AI or even deepfake? Somehow that might be also relevant to or arising from the platform.
I have sort of briefly, thank you, that's very interesting. So I have briefly thought about this question of where it puts these big platforms in relation to generative AI, for example. And I think they will be in a bit of a pickle because generative AI is much more clearly their baby than of third parties. So the immunities are immunities because platforms can say, look, the content I forwarded to you is not my content, but it's the content from a third party. Whilst you know, with generative AI, it's very clear that, you know, the ChatGPT or so on does editing work. In fact, that is the main feature. So in other words, I don't think, but I have not read about this, but I should investigate, but I don't think the immunities would at all extend to generative AI, to platforms and their generative AI. But then the next question is, well, would a negligence potentially apply to them? Yeah. Again, I'm not entirely sure, but certainly I think the immunities case would be pretty weak.
And thank you. So we got a question from our audience, Mr. William Martin Miller. So I'm now reading the question to our audience as well. So the question is about a new bill in Australia. He said that the Australian government has enacted the Communications Legislation Amendment combating misinformation and disinformation, Bill 2024. The aim is to provide tool powers to combat harmful misinformation presented through online platforms, particularly for under 16. It means every Australian will need a digital passport, ensuring they are old enough to be interacting with the online services of their choice. Does this render any immunity on the part of the platform if they adopt the digital passport system, given the onus will now be on adults obtaining digital passports? Do you envisage this Australian initiative giving more neutrality on the part of social platforms, provided the platform implement such controls in the public interest and compliance with new laws?
Okay. I mean, to me, I would think that it doesn't get platforms off the hook. If you, in terms of, let's say, in terms of negligence. So I think it will make, you know, having a type of digital passport might make platforms compliant with legislative requirements which say, oh, you must have age restrictions. Yeah, and I think that's a good thing. If there should be age restrictions for certain things, platforms need to think hard how they implement that, and having digital passports might be a way of doing it. I've not looked at it, so I didn't even know it existed, but it's very interesting. Yeah, so I think that's one thing, and it deals with having age restrictions for children. But it doesn't, of course, mean that platforms from now on will be, you know, will be not liable, would have no liability and negligence if the immunities were interpreted more narrowly. Because, you know, for example, I mean, the viral challenges, but this blackout challenge was used by teenagers, and it was, you know, it was used by a 10-year-old, but also by a 15-year-old, and also by a 16-year-old. And so I think actually there may still be examples where, you know, there is very unwholesome content being presented by potentially vulnerable people, and it's not as if, you know, at the age of 16, you suddenly stop being vulnerable. Yeah, and there are all sorts of other vulnerabilities which may potentially, you know, expose platforms to liability because they're not moderating their content adequately. So I think that's a good step, but I don't think it would mean that platforms had no broader liabilities, assuming the immunities weren't there or were more narrowly interpreted.
Thank you, Uta. Since we do not have any further questions from the audience, if not, then so we are about to close the session. Before we do that, I would like to invite everyone to join me thanking Uta for the great sharing. And for those who are interested in the topic, I would highly recommend you to read Uta's paper. So I already put in the chat box, and then you can download that or read that online. That is a paper published in the Journal of Media Law just this year. Thank you, Uta. And I wish all of you a very nice weekend. For those of you who celebrate Thanksgiving, also happy Thanksgiving.
Thank you, Gian. It's been a pleasure.
Pleasure's ours.
Okay, bye-bye.
And yeah, stay tuned. We will have more events next year.